we'll have to be super wise on using our time because I understand that your schedule today is it's simply nuts. So let's use it wisely, and let's talk about soccer then. So as you know, that's the one thing that we do in Brazil, which is begin every single conversation talking about football. And as far as I understand, you are an Arsenal fan.
Yeah.
Is that correct? So do you know?
But yes, yeah, yeah.
This is a small trivia. Arsenal is one of out of five teams that have beaten the Brazilian national team on matches that happened in 1965. So that's the one thing that you guys are learning today. So if there's like a one thing that I might be saying that it might be something that you didn't know is that. So Arsenal end up winning a match against
Really?
Brazil in 1965. It was really something that for us, it's somewhat pitiful because you know what? Like all the players from the Brazilian national team, they play at Corinthians. Which is a team from São Paulo. So if some of you support Corinthians, now you know the damage that you took from us. But Flamengo won over Brazil once as well. But jokes aside, Nick, knowing that you are an Arsenal fan, and of course, Brazilian national team is our proud of joy in terms of sovereignty as well. Let me begin with one thing that you mentioned about data sovereignty. Last year, IGF was held in Paris, and by the end of the event, Macron gave out this speech saying that Europe should offer a middle ground between two ideas of internet regulation. One coming from the Silicon Valley, focusing much more on innovation, and the other one coming from China, focusing on state control and direction on what internet should look like. When Mark Zuckerberg ended up giving this speech as well, signaling that GDPR might be a blueprint for future regulation, and I know that yourself has said in the past that Brussels will definitely play a role in creating this middle ground. Which middle ground is that? What
Yeah.
this type of regulation would look like doing this comparison between on one way Silicon Valley, on the other way China?
Um, I mean, firstly, I was there, and I thought the way that Macron framed it was exceptionally good because I mean, everybody. I mean, like any good politician, he frames it in a way that serves the purposes of his argument rather well, and indulges just a little in caricature. I don't think it is true to say. It might have been true, by the way, a few years ago. I just don't think it's true anymore, at least in my experience in Silicon Valley. I don't think it's true to say anymore that people in Silicon Valley have a sort of libertarian aversion to any form of regulatory intrusion in their sector. I think that may have been the case in the beginning, where there was this sort of belief that government should just stay out of the way of industry and so on. I think everybody now accepts, most people now accept that what particularly these data intensive industries are dealing with goes so much to the heart of profound social, moral, ethical, cultural issues that it's not something which industry should arrogate to itself. So I think he put it well. I mean, but it's interesting to see what, of course, the Macron government has done since then. Because I believe his intentions, and reasons nothing to do with Facebook. I know him a bit, and I've spoken to him about this. I think he's sincere in trying to strike the balance. But when the debates have then gone into the Assemblée Nationale, they've recently produced legislation which is actually really quite intrusive, quite similar in some important respects to Germany's Netz DG law, which of course we, like all companies, abide by. But it's quite heavy-handed because it's basically saying to private companies that private companies should make the decision about whether something is illegal or not.
That's the one on hate speech.
Yeah. And then we find ourselves in the peculiar position, for instance, in Germany, and possibly now under the new French law, which was passed following Macron's otherwise very well-balanced remarks, where we sort of try and guess what would be judged to be illegal or not. And then we end up in court being told by German courts that we shouldn't have taken them down in the first place. It's almost a role reversal, what people expect. So I think it's easier to describe what the balance is than to do it in practice. And I do think Europe plays a disproportionately important role just because Europe has got, has got such significant regulatory muscle. I think there is a greater capacity for EU institutions to regulate with precision than is often the case, for instance, in Washington, D.C., where you have such antagonism between the two parties. It's very difficult for the Republicans and Democrats to just agree on even basic things like federal privacy legislation, which is still not yet emerged in DC. So, and of course, the interesting thing in Europe is that Europe has got this great rule-making capacity, and yet the sort of technological battle for dominance really is being played out between America and China. So you've got this really interesting sort of three-way sort of interplay where you've got Chinese technology companies, Alibaba, Tencent, and so on, based on a completely different philosophy on data, surveillance, and so on to what we're accustomed to in inverted commas, the West. You've got American companies, predominantly American companies, rivaling them at scale, and you've got a European continent that doesn't have any big tech giants to rival those American or Chinese companies, and yet probably in the strongest position to set the rules of the game in which they will conduct their competition. So it's a bit, I mean, in one way, it gives Europe more freedom because they can, in a sense, make these rules without worrying too much about their own commercial vested interest. But it has a danger, and I think the danger is that Europe ends up legislating almost out of a sense of pique against big American tech or big Chinese tech, and that's I was a lawmaker for 20 years. It's a tempting but dangerous motive to wield the legislative pen to spill legislative ink in trying to sort of correct a commercial imbalance. That's often not the best way to do it.
And when we are addressing those laws, we're talking about the German law and the French law. We're working on the national level. But on some specific areas, there is already a regional regulation on some issues. And copyright might be one example. Brazil has just begun open up a public consultation on the reform of the copyright law, and of course we all know here that Europe has approved the revision on the copyright directive, and especially on Article 15, 17, you have two provisions that might end up like changing the way in which information flows and how different business models might be conducted. Would love to hear your opinion on those provisions on the reform of the copyright directive concerning the way that journalism content will be handled through the links, and of course the other provision on Article 17 that people call the upload filter. How do you see that changing the way in which
well, unless you want to, I don't suggest we go into a very immersive discussion on the different provisions of the EU copyright directive. I mean, look, the overall, I mean, no one's going to disagree with the overall, and we don't, with the overall objectives, which is to give rights holders kind of guarantees over their rights, over their intellectual property, and so on. The danger is if you get the balance wrong, and if you don't have the right kind of exemptions included, it can have a chilling effect on freedom of expression, or rather, it builds in incentives for. Not just Facebook, but poses big dilemmas for YouTube and for others. If you're not careful, you end up having to sort of almost overcompensate and depriving users of content that otherwise they much enjoy using. So, like all these things, it's a difficult balance to strike. And of course, it relates to this wider debate about whether platforms like Facebook have the same kind of liability for the content that they carry as a traditional publisher would. And I mean, for me, it's pretty clear that of course it's not the same. Of course it's not the same. I mean, Mark Zuckerberg is not a newspaper editor. He doesn't commission the content. We do. I post a picture of my football mad teenage sons or our pet cat or my birthday cake. I mean, it's an auto generation of content. So of course we can't. Of course the platforms aren't remotely the same as those who commission content, and therefore clearly don't have the same legal liability for it. I personally think that, but we do have a responsibility, as I tried to describe earlier, of setting sensible rules about boundaries for what that content is. I think part of the problem here is that I totally understand this. You've got industries, particularly publishers, quite understandably feel challenged by the presence of these new platforms, and then decision makers try and duplicate the terminology for an existing industry onto a new one, but it doesn't really work. I mean, the whole point about particularly social media platforms is they're just a different kind of industry, and it's a different kind of communication technology. It's not one which is commissioned and curated in a sort of top-down way, in a way which the traditional publishing industry is. And so I don't think it carries the same kind of legal liabilities and responsibilities.
I see. And I'll love to delve deeper on discussions on liability, but we won't have much time. So just a final question for me. Addressing those issues on liability, the company has announced the oversight board recently, and I understand that there's a lot of information that is still coming up on how the board will function. But as far as we understand, the board will have, of course, a limited capacity on what type of contents and the amount of contents are going to be reviewed by the board. So, of course, the board will not solve all the questions concerning controversial materials. But on the other hand, how this board is going to be deployed? Because I understand it's like 40 members of the board, and they will have the final word on how to apply the community standards, as I understand. But since this will not, of course, fix all the problems, what do you see are the biggest advantages of the board, and what are the shortcomings of the board? What it can do and what it cannot do, what it might solve and what it might be left for other initiatives to address?
So what it's trying to solve is it's trying to solve the dilemma that Facebook, on fraught issues of dispute around individual pieces of content, acts as judge and jury, and that's what it's trying to solve. It's trying to take it's trying to take the power and authority of Facebook to decide not only its own rules but also the adjudication of those rules out of the hands of Facebook. So that's what it's trying to solve. What it's not going to do or trying to solve is to sort of rewrite those policies and those standards for Facebook. In other words, the panel, I mean, it's only vaguely, but very, very vaguely analogous to a court, will be able to make individual decisions on individual disputes, but not unilaterally write the content or rewrite the content policies which set the context in which those disputes have taken place. I think you're right to point out that we have a real, in fact, funny enough, I was just earlier this afternoon, because one of my teams is doing this work on this as we speak. I had a video conference call with them. One of the many dilemmas is how do we deal with the sheer scale of the potential number of disputes, and how do we ensure that the cases that the board hears are emblematic cases. I mean, that's where it'll be most useful, is that you'll have cases heard which have application more widely. And then, by the way, the board will be able to recommend. So let's say if the board says, I don't know, let's say if you you post a photograph of your stroking your cat, and we take it down because we say, no, that cat is an evil symbol of a hateful, illegal sect. And you say, no, it's not, it's just my cat. And we say, no, it isn't. It goes back and forth. And then you appeal to the board. And you win. And the board says, no, it's just a cat. Then obviously, and crucially, we will say this right from the outset, we will have no discretion as a company as to the application of the recommendation from the board. We will have to do for that bit of content what the board tells us. But the board will also be able to say, look, you've really got to have a look at your policies because they really don't make much sense or they're not clearly written. they won't be able to rewrite that, but we will then, of course, take those recommendations very seriously, and then the policy teams who work for me on this will see whether we can recraft the policy as well. But look, of course, it's going to be difficult. But candidly, since you asked, my worry is we're raising expectations that this board is going to be able to answer to everything when it's not, and there's going to be a heavy excess of cases that want to be heard, as opposed to the number of cases that can be heard, and so managing those expectations is going to be quite tricky.
And the usage of those cases, just to think about the case of the cats, will it create some sort of precedent towards photos about cats, or towards like obscurantism theories about animals, or like I believe that it will be people trying to pledge that one specific content should be taken down or should be reinstated because the board had said so, or something similar to that in the past. So it's going to be interesting to see from some sort of a precedent rule would end up applying to the board.
Well, yes is the answer. I think it wouldn't make much sense to do this unless you accepted that the rulings would set precedents. Now we would still be free as a company to say, okay, we will take it down or keep it up if that's what you say, but we still believe in the policy and we're not going to change the policy. But there'll be immense pressure on us to change the policy if the policy in the analysis of the board is found to be faulty.